Someone make it make sense.
Probably a couple.
Welcome back, everybody, for take two. Hopefully this solves some of the technology issues. I have no idea. I mean, if it could just be, again, if it's just StreamYard and YouTube issues, then, you know, and it still causes problems, then we'll just try again tomorrow. But hopefully I'm resetting everything has helped. And, you know, also fingers crossed, positive and optimism, positive thoughts and optimism, right? So what has happened before is we were only just getting started. We watched part of this hearing. I backed it up, actually, since we missed a bunch. But essentially, this is the hearing from April 30th on the defendant's motion to continue the trial. And again, this is based a lot on, you know, they've had all these issues with the conflicts of interest because of Dan Rashbaum, and they just keep finding and uncovering more issues. And I expected this to be granted because of all that. And most recently, they discovered that the investigator was also tainted. And so, but what was really interesting that I think we're going to be able to hear again, because I backed it up, is that there was something in the sealed portions, or, you know, the seal, they filed these motions to continue, and then the response is under seal because of the fact that it's dealing with things like the attorney-client privilege and the conflict of interest, which again is going to involve attorney-client privilege. And so so because of that, we didn't get to read them. But apparently what happened was there was talk in those filings, right, of bringing superseding indictments or further charges. And we didn't know this. I didn't know this until Judge Everett just mentioned it. And so the state says that they are not going to be going forward with any other superseding indictments or additional charges. But that is interesting. And my thought is that in regards to Wendy, was it 5-0? So anyway, okay, so that's kind of where we're at. And again, I backed it up a little bit. So let's hope that things go well.
Hi, happy and welcome. And we would object to a continuance based on those pages.
All right, as to any additional raw data from either your client's phone or email accounts, are these not in your possession at this point?
We have them, but that's the materials that we've been struggling to try to get through.
Hi, James.
And again, this was disclosed back in October and November, or when did you receive it?
We did not receive those materials, Your Honor, until it was after, if Your Honor recalls, during the expedited hearing that we had a couple of weeks ago by telephone with the state and defense on the phone. Those were the records that we were addressing then, and I believe that we got those. April 10th, 2025. And that's, the state actually acknowledges that in their response.
All right, Mr. Zalman, you're not going to make your argument for you, but ultimately you believe you need to review these to be prepared for trial itself.
Yes, and those aren't the only issues that have arisen over the last few weeks. The motion details the additional issues, but needless to say, we have spent the last 3 weeks trying to collect this material, some of which we still don't have.
Seems to be working better so far, so that's good.
You're referring to the recent investigation?
Yes.
Aha!
And
There we
even if
go.
the state isn't going to use the information, we still need to know the extent to which they violated, they intercepted, they monitored attorney-client communications and communications that are protected by the fiduciary client privilege. We don't have all that information yet, and they have not responded. As indicated in my reply yesterday, the state hasn't responded to those emails requesting that information.
Ms. Dugan,
Yes,
concerning the aspect of the recent investigation, which materials are yet to be provided and why?
Her hair, by the way, always looks fucking flawless. That's Sara Dugan for the state, if anyone is unfamiliar. I don't know what goes on, but her hair always looks flawless. And the thing is, she always wears it down, and it never looks like it has tangles. There's nothing I can do at all to make my hair not be completely tangled all the time, no matter what. I don't know how she does it, but her hair always looks great.
May I also address the 100,000 emails?
Go ahead.
Okay. So those 100,000 emails are redacted privileged communications that defense recently received that occurred between the Adelsons and prior counsel. This communication was
Dan
redacted by the team. It's never been seen by the prosecution.
The filter team document
Yes,
you're
sir,
referring
thank you,
to.
filter team.
The taint
It's
team.
never been seen by the prosecution. It's obviously privileged. We obviously do not intend to use it in our case, having never seen it. And I also can't imagine a scenario where the defense would be using it in their case. I would feel like all of that information would be hearsay and self-serving hearsay. So the state is objecting to a continuance based on their needing to review all of the privileged communications with prior counsel.
When were the filter team documents provided?
They were provided on April 10th during Jason Newland's deposition by this defense team. Somehow some question was asked where he referred to the filter team that the court referenced, and this defense team was not aware that the filter team had gone through all of those emails and kept all of the privileged emails from the prosecution team and provided them to former defense counsel. So these were then provided to this defense team.
Very well.
And Your Honor, I can address that very briefly. Judge, advice of counsel is something that would be relevant. It goes to Mrs. Adelson's state of mind. And if there are any emails in the records that we received 2 weeks ago that would rise to that level, then it would absolutely be relevant and admissible. If it goes to her state of mind concerning, for example, her leaving the country.
Well, I was going to say, particularly as to that issue, what advice you received and what you...
This makes sense. Because as we all know, the hot mic, right? When she says that they're going to go to Vietnam. Okay. So, well, now the defense just made that really clear. So some of these, the 1,000 emails or whatever, that's attorney-client privilege with former counsel, must have been follow-up discussion on their ability to leave the country and should they stay or should they go and all that. And I guess what they would present. Now, here's the deal. So if in those emails, right, because it's, okay, let me back up. So as far as the phone call, right, where it was Donna says we're going to Vietnam, the reason the reason that's able to come in is because it was her on the phone with Charlie, and both parties have to waive like any type of privacy or whatever. Like, in other words, to use the jail phone call, right? Your phone call is being recorded, da da da. And what happened was Donna forgot or didn't realize the phone was still on. She thought the call had been disconnected. So she's got the phone set down. She's over there talking to her husband, Harvey, and whoever. And that's when she says, yeah, we're fleeing the country. And then she says, yeah, Dan says, da da da. And she says, and Dan Rashbaum was their prior counsel. So she's actually saying what he told her legally that they're allowed to do and says they're fleeing the country. And of course, this is huge evidence of they arrested her, Donna, at the airport about to board the plane. So the difference being when it comes to these 1,000 emails of Donna speaking with her prior counsel, there could be anything incriminating right in there, right? As we know, the defendant's statements are fair game. However, not when it's privileged. And because it's prior counsel, it's still privileged. So essentially, here's where the defense has an advantage, because there could be any type of damning shit in those emails between Donna and her attorney, and whether she's saying it or whatever in regards to leaving the country, and it could be really bad for her. However, the state can't bring that in because it's privilege. The only way any of that would come in is if Donna waives privilege, and so then they get to pick and choose, right? So in other words, what he's referencing, I'm going to back it up. What he's referencing is about state of mind leaving the country. In other words, what they would do is they would pull out the emails where she's like, I love being here in Florida and I did whatever, to try to prove state of mind that there was no intention to flee. And there could be emails in there that are extremely damning for her that say the opposite and deal with going to Vietnam, but those are not going to come in because the defense wouldn't offer them. They wouldn't bring them in. Why would they, right? And there's nothing the state can do because it's attorney-client privilege. And the only person who can waive that is Donna. And she would only waive it for the specific emails or portions of an email that the defense would intend to offer. So hopefully that makes sense.
And if there are any emails in the records that we received 2 weeks ago that would rise to that level, then it would absolutely be relevant and admissible. If it goes to her state of mind concerning, for example, her leaving the country.
Concerning, for example, her leaving the country. And that's why I wanted to mention it, right? Because it's like, there's got to be damning shit in there as well. But because it's privileged, the defense gets to keep that to themselves and the state can't bring it in. But the defense can choose to bring in things, even if it's privileged, if Donna waives privilege. Now, having said that, that doesn't mean it's admissible yet. This is what they're arguing. Because it's still hearsay, it still may not come in. We're going to see what Judge Everett says.
And so, particularly as to that issue, what advice she received and what she relied upon in making that decision. The final fact determine, was she relying on the advice of counsel or was she in fact trying to flee? The emails, though, and your client does not have to testify. But
that's a whole other problem, right? Because really, the advice of counsel, I mean, when that happened, I was like, holy shit, Dan Rashbaum's going to be disbarred because he's basically encouraging them to leave the country. And literally, Judge Everett says as much, that the finder of fact would have to determine, was she following advice of counsel or was it her decision? Now, here's the thing. It's better for Donna, right? If she can be like, oh, I was following the advice of counsel, right? Because that's fair. That's fair to her. If you're Donna, if you're the jury's assessing Donna, it's fair. It's like, oh, I was following the advice of counsel, da, da, da. However, it's a whole separate problem for Dan Rashbaum because counsel can't tell you to fucking flee. Counsel can't do that. That's disbarred, right? So, so in other words, that's a whole other set of issues. So let me back that up. This is really interesting. And the jury would have to decide, was it her own? So if the jury decides, or if the evidence bears out, if it comes in that it was her own decision, well, that's better for Dan Rashbaum, but that's a lot worse for her, isn't it? Hi, Flash.
That would be up to the finder of fact to determine, was she relying on the advice of counsel or was she in fact trying to flee? The emails, though, and your client does not have to testify, but ultimately this would go to how would the emails themselves be admitted versus her giving her recollection or recitation of.
In other words, the only way that any of these emails are going to come in is if she testifies. Now, having said that, there's been other things that have come up. I forget what it was specifically, but there were other pieces of evidence that were discussed months ago that literally the only way they would come in is if she testifies. And I remember thinking, oh, she's definitely going to testify. Like there's some of this stuff that she wants to bring in. There's no way it's coming in unless she testifies. So it's almost like a done deal. Like she's already decided. They're planning a strategy around it. But these emails would be another example of where there wouldn't be a way to get them in unless potentially when she's testifying, if she testifies. Because how would they get them in, right? You need a witness to bring it in. You're not going to, Dan Rashbaum's not going to be the witness to bring, you know what I mean? It's like, they don't have an option. You need a witness to bring it in who has had dealings with those emails and was responsible for participating in those emails. And if it's emails between Donna and Dan Rashbaum, then yeah, Donna's going to fucking take the stand.
That still doesn't mean that the emails themselves would not be admissible, Your Honor.
Let's put a pin in that. That be subject to any.
Yeah, let's put a pin in that. He didn't answer the question.
Argument in the future as to how the emails themselves could be admissible. But if your client chooses to take the stand during the trial and waives any prior privilege with Mr. Rashbaum or anyone else concerning advice that she received on leaving the country, that is certainly up to her.
Yes, sir.
Wow. So I'm going to reiterate so what he just said. If Donna Adelson takes a stand and decides to waive privilege with communications either between her and Dan Rashbaum or any other counsel, and decides to waive privilege so that statements can come in as to her state of mind about leaving the country, that's her choice. All right. I would expect she's going to take the stand and she's going to try to use these emails to show that she didn't want to leave the country. Good luck with that. This is going to be really interesting.
Back to the Lisa investigation discovery, Ms. Dugan, the items that have not been provided, I believe some of these pertain to the parameters in the Title III that we're supposed to operate as safeguards. Is there a reason this has not been provided to the defense?
So looking at the reply and the motion to compel, all of those, the things that they're requesting here as far as the minimization instructions, all the logs, all of those things, I feel once the order to unseal has been signed, those can all be disclosed. The only thing that I saw that would be additional that they are asking for is surveillance video, which is surveillance video from the jail, which I've been told has already been disclosed to the defense. They also asked for the financial records that are mentioned in the application. I was told that we subpoenaed Harvey Adelson's Zelle account. I found that those Zelle records and had it sent to the defense this afternoon. So once those items are unsealed and they can be disclosed to the defense, that should be all of the discovery that pertains to the wire.
Please provide the order.
Oh, right.
Able to take a look at it.
No, sir.
Right. Because that's right. I failed to mention there's been additional wiretaps that were conducted, right? We know wiretaps were a huge part of this back in the day. There's been additional of that going on. And so additional evidence was uncovered. And that's what they're referencing when she says the wire.
Let me show them what I have, and if I need to change anything, I'll do.
I'm glad though that the technology is working a lot better. That's such good news. Such good news. James has never heard of this trial. Are you kidding? We talk about Adelson's all the time when we're watching other things. Where's Heather when you need her? Whenever we talk about Wendy, like even all the Wendy jokes, right? you know, for example, all this type of stuff. Hold on.
Yesterday, I was taking a walk around 5. I met a new friend. We went to Tallahassee food trucks.
Wow.
Last night, hung out with her for hours.
Yeah.
Wendy made another new friend. Are you fucking kidding me? Why?
She also Googled. There was a shooting, do you know?
I know.
Both she and John.
Stop.
Why would they
I'm
Google?
going to die.
Why would that just come
I'm
up?
going. Sorry, Heather. Heather says, "I met a new friend on a whole hawk. Bitch, how old are you?"
My friend Elizabeth is a mortician. She's the prettiest mortician I've ever met.
You guys, Andy's friend, the fucking mortician. What is happening?
I ate a lunch. Like I had a whole delicious lunch.
There's more. All of those Wendy, all the Wendy jokes, all the Fievel jokes, even the Fievel emoji, all that. That's Wendy Adelson. She's going to be the last one, in my opinion. They're coming for you, Fievel. They're coming for you. And so right now, Fievel's mom is going to be going to trial. I believe they're still slated for October, but we're going to get into all that as we read all these recent documents that came out during the Karen Reed trial as we're getting caught up. So yeah, this was the one. I mean, I feel like you know this, James, and anyone else who's like, wait, what is this? So this is the Adelsons, right? So Dan Markell, Florida State University law professor who taught Peter Tragos, was murdered in 2014. So this case has been going on for 11 years, and there's been numerous convictions already. And the trial that's happening now is Donna Adelson, right? And the last one I think they're going to come for is Fievel, Wendy, who was Dan Markell's wife. So yeah, hopefully that helps refresh people's memories / start their memories brand new if you really haven't heard of it. There's a lot more to it. This is also the one if you've heard people making jokes about actually laundering the money or fleeing to Vietnam, and that's on a recorded call that you're going to flee to Vietnam because they don't extradite. There's a lot more. There's a lot of really there's a lot of memes that have come from this whole saga, as well as really fascinating lawyering, especially from the state, and then a lot of really interesting issues that arose from prior counsel with Dan Rashwell. There's a lot to this one. And as with all the cases that I cover, right, there's a whole playlist for anyone who's like, I want to get caught up. There's a whole playlist for the Adelsons where we go back and we watch parts of Charlie's trial, we watch parts of Katie, we watch parts of the prior trials, we watch the interrogations, we cover all the filings, we go through all this stuff, right? So so anyone that wants to get caught up, check out that playlist. And what I will say is that there's no gavel to gavel trials, so it's not as lengthy as maybe some other playlists, because what we've done is we've really hit the highlights of the previous trials, and it's not like a gavel, because otherwise it would be like several gavel to gavel, 3 or 4 gavel to gavel trials. So this is nothing too daunting, right? In other words, it's quite manageable if you want to get caught up to speed. And hit the high notes of the trials, see the court filings, see the probable cause affidavits, which are beautiful. If you want to see what a real probable cause affidavit looks like, I've got that on one of the live streams where we read Katie McManaw's PCA. It is what it should look like, and compare it to the other cases that we follow. But yeah, ABC's docket had a whole delicious lunch. Love it for you. Let's watch that one more time. Also, welcome. Where is it?
I ate a lunch. Like I had a whole delicious lunch. My friend Elizabeth is a mortician. She's the prettiest mortician I've ever met.
You guys, Andy's friend, the fucking mortician. What is happening? James is asking about Daryl Brooks. I watched that gavel to gavel back in the day, but I've not covered it. But it is a really, really fucking good one. Wi-Fi is bad for you, Candace. So I see. It seems like my issues, or whatever the issues were, have resolved themselves. So, but I'm sorry that you're still having Wi-Fi issues as well. Oh, Mike. There you go.
Can I approach?
You may.
Your Honor, there was one issue that Mr. Newman and I addressed concerning the motion in order, and it has to do with the discrepancy with Investigator Newland's memorandum, the 17-page memorandum. The memorandum that he authored indicated that the wire went down February 24th. Ms. Dugan is telling me that the wire actually went down on February 21st. So we can just make sure that that's accurate.
Yeah, it just needs to be
Justice,
accurate.
one of the
It
paragraphs
needs to be accurate for the record.
in the defense's reply, that was just a mistake on the memo. The wire came down on the 21st. I believe the significance of the 24th was that was when the order was signed, and I think Mr. Newman's memo said the 24th, but it is the 21st, which is reflected in the order the court's looking at now.
All right.
Court will sign the order at this time. I believe that deals with your motion to compel, Mr. Zellman.
May I address one more thing about the issue we were just talking about? There is obviously this new discovery from this lead that the state was alerted to last fall. We conducted this investigation and followed that investigation to its conclusion.
Oh my God, what was the lead? I
That
want to
obviously
know.
has resulted in some new discovery in these wire calls, but I did want to let the court know,
Oh my
though there are a large number of calls
More
that
new
the defense, of course,
discovery?
wants to review. There are only, I was told about.
I mean, this is amazing, right? Again, this was going on for 11 years. They've already tried so many people, and they had a new lead, new wiretaps, and they've got new discovery. Amazing. Amazing.
Something calls deemed pertinent
My
by
choice,
law
yes,
enforcement.
the
And the state likely
Adelsons.
plans to only use maybe one or two at trial, and believes that the 2 months the defense had from the time it was discovered to the time of trial in June should be sufficient to prepare for that portion of the trial.
Do any of the calls that you intend to use from this recent investigation go to privileged matters or encapsulate
Thank you.
calls with counsel?
Thank you. I wanted to address that. There are no calls that were recorded between the defendant, Donna Adelson, and attorneys in this case. I specifically asked the investigator about that before the hearing.
Mr. Zellman, you may continue with your argument.
Yes, Your Honor. The state has also not responded to our request to let us know if they've also been monitoring our attorney-client conferences at the Leon County Detention Center.
That's enough.
And although the state believes that we're going to have enough time, I calculated this. There are over 32 hours of calls that were captured on that wire. And given the amount of materials that we have just been handed, we have not had an opportunity to review even 2 hours of those calls up to this point. Your Honor, just because the state believes that there's going to be enough time for us to prepare, and it's not 2 months, it's more like 6 weeks. There's not enough time for us to analyze this new information, synthesize it, prepare appropriate motions. We've spent the last 3 weeks dealing with this as opposed to finalizing the motions in limine.
That is an important point you bring up. Essentially, between what has been recently investigated and what the charges have been of murder, solicitation, and conspiracy from the time your client is charged, there are essentially two different pots, if you will. For the motions, that deadline was today as to the murder, solicitation, and also the last count as well. Are those motions completed?
No, Your Honor, we've only had an opportunity to finish 2 additional motions that have not yet been filed. And I have not had an opportunity because we had to adjourn Mr. Newland's deposition to finish the Frank's motion.
They're filing a Frank's motion? That's not come down yet because it's not on the docket. A Frank's motion? Are you serious? Holy shit. Oh my God. Wow. Wow. Okay, we missed a lot during Karen Reed. Holy shit. James is asking a question. I studied law or like courtroom type work. You can't remember? I feel like I've talked about it a lot. Like, yeah, I was studying law for fun, and then I got my paralegal certificate for fun. And now I'm putting all of that knowledge to use in a law firm. And as the sole paralegal for 2 really high profile defense attorneys who defend clients charged with first degree murder, among other really serious charges, both federal and state. So getting actual practical experience, and I'll be going to trial whenever they have their next trial. I'll be going to trial. But yeah, actually it is absolutely freaking amazing. So, and then another question, did I cover the homicide? I did not cover that. Chad Isaac, I've never even heard of it. Was it televised or were there cameras there? That's okay that you have a bad memory. That's okay. Yeah, were there cameras? I've never heard of that one though. Okay, interesting. Wow. Chad Isaac. So yeah, and you guys, I've got endless great stories about working. If you guys want to hear them, I feel like I could go on and on, but I've got endless great stories of all the things that happened there And anyway, so okay.
Right? So you are in fact asking for an extension on the deadline to file your motions.
We're going to need one in addition to continuance. Yes, Your Honor.
Yeah. So they're gonna and what we're gonna see is one of the next filings I think that we have. There's gonna be an amended scheduling order. So they've got a motion to continue trial and then amending the deadlines for all the other motions. Again, we've seen this in other cases. But yeah.
Ms. Dugan?
If the court wants to give an extended motion deadline, we don't have any objection to that. We do object to a continuance of the trial and remain ready for trial.
What is the defense? Well, before I come back to you, Mr. Zellman, what is the prejudice that the state would suffer if the trial is continued, Ms. Dugan?
Yeah, great question.
Beyond just a mere objection.
We would not suffer prejudice, Judge. We're just
Yeah,
ready for trial if it goes to continue.
Mr. Zellman, what would you be proposing as a date? And you also have to keep in mind.
Did y'all hear that? Because just last night we covered all the Brian Kohberger recent documents and the judge's order on the motion to continue and all that. Listen to this, guys. Listen to this. Listen to this. Remember, this murder happened in 2014, okay? 2014. So I'm saying that because when you think about justice for the victims, which is what one of the state's main arguments for Brian Kohberger to not continue the trial, right? And one thing that Judge Hippler brought up a lot, right? Prejudice to the state, right? Was referenced a lot. Listen to this, okay?
What is the prejudice that the state would suffer if the trial is continued?
What is the prejudice that the state would suffer if the trial is continued? A question asked directly to the prosecutor.
Beyond just a mere objection.
We would not suffer prejudice, Judge. We're just ready.
We would not suffer prejudice, Judge. Yeah, absolutely wouldn't. Why? Because it's not fucking possible. So I appreciate this. You guys see what a difference? Judge Everett is awesome. He's extremely fair. He's very just no nonsense, common sense. There's no bias or emotion. It's very different. I mean, it will be, whenever this does go to trial, it will be refreshing in the wake of us having watched Karen Reed round 2 and what we've seen out of Idaho, and of course there's other cases as well, but as far as the ones that I'm covering that are going to be in proximity time wise to this, just a big difference. And even if you take away the judge, right? Listen to the difference from the state. You guys, isn't this refreshing?
What is the defense? Well, before I come back to you, Mr. Zellman, what is the prejudice that the state would suffer if the trial is continued, Ms. Dugan? Beyond just a mere objection.
We would not suffer prejudice, Judge. We're just ready for trial.
We're just ready for trial whenever. We're just suffering.
What would you be proposing as a date?
I mean, thank you, Ms. Dugan. Thank you. Hi, Amelia. Happy to see you again.
And you also have to keep in mind there's only so many points in the year of a trial that could take.
Who are you now? You're an Adelson. Okay, well that's awesome. You're in the right place because we love this case here. That is awesome.
Either 3 weeks or more can be scheduled. And I assume you've discussed with your client if your relief is granted.
We have.
What that means.
We have, Your Honor. And frankly, without getting through all of this new material, it's hard for us to pinpoint exactly when. I mean, we're not going to sit around on our hands and do nothing. We have been diligently preparing. We're going to continue to diligently prepare. Likely 2 to 3 months would be, I think, realistic. But again, until we get through all these new materials, it's going to be hard for me to say.
Right. Concerning the motion deadline, which was supposed to be today, we'll set a new deadline, particularly as to the counts that have already been a part of the indictment and have been charged all along. The murder, the conspiracy, the solicitation, the deadline for filing any motions relating to the existing charges will be May 16th. The motion hearing that was scheduled to take place on that day, we will reschedule at a later point. Court is going to reserve ruling as to whether the motion for continuance will be granted. The parties are to confer about any redactions that you believe would be appropriate to the filings for the expedited motion for continuance, the state's response, and also the defendant's reply, and the motion to compel discovery. Any other matters that we need to address before we finish up for today?
Your Honor, with respect to the motion to compel, the state has also not provided the disclosures that's required by Rule 3.2201BM concerning the jailhouse informants. We are
jailhouse informants.
That material as well.
Yep, forgot about that part.
Give me a moment. I'm just going to bring up the rule.
Bring up the rule, Judge Everett. We love you.
1M, which subsection?
1BM.
1BM. Student response.
I'm sorry, Judge, I'm having trouble getting on the Wi-Fi. Is there,
This is in the discovery rule under the prosecutor's discovery obligation. And I will quote from it.
thank you.
Whether the state has any material information has been provided by informant witness, including the substance of any statement allegedly made by the defendant about which the informant witness may testify, a summary of the criminal history record of the
Hi,
informant
super planner
witness,
girl.
time
Amanda.
and place under
Good
which
to see
the
you
defendant's
again.
alleged statement was made, whether the informant witness has received or expects to receive anything in exchange for his or her testimony. The informant witness's prior history of cooperation in return for any benefit is known to the prosecutor.
Yes, sir. Thank you for that. I'm familiar with that rule, but just didn't know all of the different things that we needed to show there. Some of that has already been provided through the recordings. However, as far as her history, any benefit, all of those things, we'll disclose that to the defense as soon as possible.
Please disclose it by Friday of this week by 5 p.m.
Yes, sir.
He's just awesome, dude. I love it.
And may I also ask about today is the discovery deadline, which the state is prepared to obviously comply with. As far as though now the order on the continuance maybe being later in the week, would it be okay if we had a discovery deadline of 24 hours from the order, or would you rather keep it for today?
Concerning, again, the charges that have always been in place, the murder, the solicitation, and the conspiracy, is either party seeking more discovery on those charges that has not already been addressed up to this point.
Judge, the issue
This is so interesting. Then what all this talk about the new charges and the new, like, what? Wow.
with complying with today's deadline is we have spent the last 3 weeks dealing with these other issues. We have
Not the motions. I'm saying, are you seeking additional discovery on the indictment charges?
We are not going to be able to meet the deadline to provide the state with our discovery because we have been focused for the last 3 weeks on other issues.
Right. So then the state can't meet their deadline either. That's why he's going to have to just amend the whole fucking thing.
Student.
The state can comply with the discovery today. I just didn't know if given the possibility of the case being continued later this week, if it were possible to have 24 more hours after that order came out. But if it needs to be today, the state can comply with that. And the state would hope that the defense can comply to or get discovery as quickly as possible to us.
Once a ruling has been made on the continuance of the trial, the court will also address any deadline for discovery as well. For
Okay.
now, please operate as if the deadline remains in place. Wait for the order.
And
Wow.
Judge, I just want to make
Great.
it very clear, there's no way we're going to be able to get it done, even if we were to work straight through to
He
the.
heard you the first
Then,
time.
Mr. Zelman, as to that, what can be filed, please do.
Yes, sir.
I will let you know once we have the motion, or excuse me, once the order is on the motion to continue, whether the deadline for everything else related to today's deadline applies as well.
Yes, sir.
We are in recess.
All right. Okay, so next, because we're going in chronological order, now we're going to go back to the filings. Okay, so let me just unshare, reshare. Okay, we're getting into some of the tea, guys. We're getting into some of the tea. So first, we have this motion in limine from the defense for Stephen Webster's testimony. For those of you guys who remember, Stephen Webster testified at the other trials. He was Dan Markel's friend and divorce attorney. He comes on STS a lot. So some of this we don't need to go through, right? We know it's whatever. Here's the basic facts. Okay. So the threshold question for admission of evidence is relevance. So rule 401. Mr. Webster did not become involved in the post-dissolution litigation until May 2014. Again, that would be the divorce, right? According to his testimony in Charles Adelson's trial and his deposition in this case on August 30th, 2024, Webster met with Markel in May of 2014, the day after the pleadings he was asked to review. Mr. Webster's testimony centers on what Mr. Markel said to him about the post-dissolution proceedings, including that Mr. Markel said that he heard Miss Adelson say, "Stupid is on the phone." That's coming in all the other trials, right? And that the counter motion was filed. Mr. Webster also offers his opinion on the strength of Mr. Markel's claims and his opinion about the involvement of the Adelson family in Mr. Markel's death. His continued advocacy for the Markel family vis-a-vis participating in podcasts, speaking of STS, and interviews with media concerning Mr. Markel's love for his children and providing commentary about the case. To the extent the state seeks to elicit from Mr. Webster statements made to him by Mr. Markel, such testimony is hearsay. Yeah, I mean, it is, for which there's no exception. To the extent the state intends to elicit from Mr. Webster his opinion about the strength of Mr. Markel's pleadings, Webster is not an expert in family law. Well, he was a family law attorney. even if you were a family law expert. So they're trying to make a distinction between being an expert versus an attorney, which I don't even know how you would even try to make that distinction. But anyway, no foundation for his opinion has been established. Absent being able to lay such foundation, the court should not prohibit him from offering an opinion about the strength of Mr. Markel's post-dissolution findings. So what does this mean? Because remember, fact witnesses are fact witnesses, right? You can only offer an opinion about evidence if you're an expert witness. It's one of the reasons why it would be an incentive to try to qualify someone as an expert. That's what they're saying. Essentially what this sounds like to me is they know they're not going to be able to keep his testimony out. So now what they're trying to do is say, well, we don't want his opinions, right? We don't want him to make any opinions. So how are they going to try to do that? They're going to try to say, well, he can only make these opinions if he's offered as an expert, and he's not been qualified as an expert in family law. That's what they're saying. Mr. Webster's opinions, again with more opinions, on the Adelson's involvement in Mr. Markel's death are inadmissible. Wherefore, they request that the court grant the motion in limine. Okay, here comes the best part, guys. You guys ready? Wendy's old friend. Here we go. Donna wants to keep this testimony out. All right. Miss Adelson has been indicted. Okay, we know about that. Here's the part we don't know. Sara Yousef has been listed by the prosecution as material witness in this case. Sara is a former close friend of the Mrs. Adelson's daughter, Wendy Adelson, aka Fievel. Sara and Wendy first met when they were students at the University of Miami Law School in 2003. According to Sara, her friendship with Wendy was very close. Sara and Wendy were friends for about 13 years. I'm sorry, Sara, that must have sucked for you. During this time, Sara knew Mrs. Adelson because she was the mother of her close friend, Wendy. Because of Sara and Wendy's friendship, Sara had been to Thanksgiving at the Adelsons' home on a few occasions and been to their residence for different holidays and events. So very close friends, right? Invited to the family holidays. Sara said she was unaware that it was a highly contentious divorce and further testified that Wendy emailed her some of the motions that Dan filed. Sara described a birthday party she attended for Wendy's eldest son, which was held at Wendy's parents' condo. So here they're just showing how close they are as friends and whatnot. It was at this party that Sara obtained the only information she has regarding Donna Adelson. According to Sara, while at the party, she overheard Donna say, quote, "They're talking about him like he was a beloved professor, but you know something? He was a jerk." So again, this is a birthday party that was shortly after Dan's murder. Sara thought that what Donna said was abnormal because Dan had just died, and in most cultures, we don't speak ill about the dead. That's taken from her deposition. In Sara's opinion, Donna's statement, quote, conveyed an outsized inappropriate anger, considering that he, Dan, would never bother anyone again. Beyond that statement, Sara had no testimony related to Donna Adelson that she could offer. Sara ended her friendship with Wendy in 2017. Gee, I wonder why Sara ended the friendship. I want those depositions. Can we get those depositions? When asked if she had come to the conclusion that Donna was guilty or the Adelsons in general were guilty of doing something, Sara thought they were guilty of conspiring to murder Dan Markel. Now, this is the best part. Sara clarified that it was not all of the Adelsons, but that Donna, Charlie, and Wendy were guilty of conspiracy to commit murder and soliciting somebody to kill Dan. Now, the reason I say this is so interesting is because my interpretation all along has been that Harvey really had no fucking clue. Harvey, I always thought there's some people who think Harvey was like the ringleader or Harvey's involved. I don't think Harvey. Donna runs the show. Harvey just is there to pay the money, give the money. I don't think it's just he's really kept in the dark, I think, for the most part. And so this does not surprise me at all because and Wendy, correct. That's right. I'm going to read this again. Sara clarified that it was not all of the Adelsons, but Donna, Charlie, and Wendy, again, Sara's former best friend, that were guilty of conspiracy to commit murder and soliciting somebody to kill Dan. Amazing. So you bet Donna wants to keep this out, huh? That's hilarious, Amelia. When asked how she became a witness in this case, Sara said that after the last trial, she saw Phil Markel's victim impact statement and it brought her to tears. She also explained that the amount of time he talked about grandparent alienation and not having a meaningful relationship with the children made her feel really awful. Because of this, Sara contacted the Markel's attorney and provided him with the information she had about grandparent visitation legislation. Sara said nothing happened for a couple months, but then the Markel's attorney contacted her and said they were giving her name to the prosecutor. And Sara said she did this because she wanted to help the Markels. Okay, legal analysis. They're saying it should be excluded for these reasons. Okay. Relevance, Rule 401. And when it comes to the federal rules anyway, but they've got Florida case law that they're going to cite. Pursuant to the Florida Evidence Code, relevant evidence is defined as evidence tending to prove or disprove a material fact. Well, that's identical to the federal standard. But anyhow, here, the only relevant testimony that Ms. Yousef can offer regarding Ms. Adelson is the statement that she said Donna Adelson made to her about Dan Markell being a jerk, as evidenced in the deposition. So in other words, what they're saying is all the other stuff that Sara said, right, about like who she thinks killed Dan Markell, they're saying it's not relevant, you guys. They're saying it's not relevant. Now, there's other issues that I'm sure the defense will raise, but relevancy, you've got to be kidding me. You've got to be kidding me. So they're saying the only thing that's relevant here is Dan Markell being a jerk. Why? Because they want the jury to hear that he's a jerk. This is hilarious, guys. It's like, oh, her opinion that he was a jerk, that's fine. But nothing else about being murderers. As evidenced in the deposition, Ms. Yousef gave on August 23rd, she testified that other than that single statement about Dan Markell being a jerk, she had no other admissible testimony that she could offer about Donna Adelson. While this statement may be admissible, the rest of Ms. Yousef's anticipated testimony, including her opinion concerning Ms. Adelson's guilt, would be inadmissible at trial. I don't give a shit. I want it to come in. I want all of it to come in. To permit Ms. Yousef to testify concerning her opinion would be grounds for mistrial and reversible error, as a witness opinion about guilt or innocence of the accused is inadmissible. Yeah, right. You can only offer an opinion if you're, like I was just saying, if you're offered as an expert. So here's my question. Ms. Yousef, what are you great at? Name something and let's get you in as an expert and let's get all this in. That's what I think. All right, admissibility, right? So now we move on. They've discussed the relevancy test, so that's Rule 401. Now we move on to admissibility. So now we're at Rule 403 and 404, but we go in order. 403. All right. Even if the court finds, so when I say 403, you guys know, right? That's the balancing test. Prejudicial versus probative, jury confusion, waste of time, cumulative, all that. All right. And literally there it is in writing. Every time I talk about it, it's like they all keep reading. Even if the court finds evidence relevant, as in, let's say it passes the test for relevancy, Rule 401, like I said, you go in order. Then you move on to Rule 403 to determine the admissibility further. It can be made inadmissible if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, or needless presentation of cumulative evidence. Yep. And here they're citing the Florida statute, but again, this is identical to Rule 403. Okay. Here, the anticipated testimony of Ms. Yousef about Wendy Adelson is inadmissible because its probative value would substantially outweigh the danger of unfair prejudice. Yeah, it is unfair prejudice to Ms. Adelson because she is guilty, and Sarah's right. You guys, I have strong feelings about this case, obviously. Ms. Yousef testified in her deposition that she felt sorry for Phil Markell after listening to the victim. And that I don't think is relevant. That doesn't need to come in. Irrelevant. We just get to the good part. Just need the good part. This is bias. Oh, so when they want that part in. Oh, hilarious. They want that in. They want that in. Oh my God. It's really not relevant at all. They want it in. Holy shit. It's just bias. Oh my God. Hearsay. Under Florida law, hearsay is, well, under all law. Now the court statement introduced a trial that is made by someone other than the declarant to prove the truth of the matter asserted. Now, I need to say something. They've added other than declarant. Why? They went ahead and added in one of the exceptions. The actual definition of hearsay, right? A statement made outside of court that's being offered for the truth of the matter asserted. They added other than the declarant. Why? Because one of the exceptions to hearsay is the defendant's own words, right? And actually, looking at this closely here, that's interesting. Then maybe there's more to that. Hold on, let me think about this. Because, yeah, the declarant. So in Florida, it looks like they've got more room for hearsay than elsewhere. Because here's the thing. Okay, let me pull it up on the. Or not pull it up. Open up the book. Okay, because here's the thing, guys. That elsewhere, like everywhere else, right? Even if you're the declarant, your own statements are still hearsay if they were made outside of court and they're being offered for the truth of the matter asserted. So Florida is more lenient here. Let me read this. This is crazy. Okay, so the official definition of hearsay, right? So go from the federal rule. Okay, so So statement. Statement means a person's oral assertion. These are the definitions, right? Statement means a person's oral assertion, written assertion, or nonverbal conduct if that person intended it as an assertion. Declarant is the person who made the statement. Hearsay. And here's the hearsay definition. Hearsay means a statement that. Oh, it does say declarant. Okay, it does say declarant. The declarant does not make while testifying at the current trial or hearing. So not a court statement. So that would include the declarant, right? So in other words, so let's say that you're the declarant and you're also the one testifying, right? Then you're both. If you're a great example of this is Amber Heard, because Elaine was very confused about this in Deputy Heard, and Camille had to remind her over and over again that Amber Heard's own statements, when Amber Heard was on the stand and she was trying to say, here's what I said, and it was a statement that she had made outside of court that was being offered for the truth of the matter asserted, it was still hearsay, right? Because Amber Heard in those examples was both the declarant and the witness. But you could also have a situation where there's a witness who is not the declarant, but is wanting to offer testimony that could be hearsay, and it's somebody else is the declarant. In other words, let's say you're a witness and you're like, Sally told me, da-da-da-da. Sally's the declarant. Sally's doing the one that did the telling, right? Okay. So the declarant does not make while testifying in the current trial or hearing, and the party offers an evidence to prove the truth of the matter asserted, right? So what's interesting is when you look at this under Florida law, they're saying other than the declarant. Different. I learned something new today, guys. Florida literally has a completely different interpretation of hearsay. That is why, clearly now it makes sense. That's why they cited the Florida statute and not the federal rule, because, wow. Because the declarant's own statements, if they're offered for the truth of the matter and they're made outside of court, they're still hearsay, but not in Florida. Interesting. Okay. Also, except as provided by statute, hearsay evidence is inadmissible. Most of Ms. Yousef's anticipated testimony would be inadmissible hearsay. Because the defense expects the state to call Wendy Adelson as a witness during trial, oh my God, and much of Ms. Yousef's deposition testimony consisted primarily of things that Wendy Adelson told her Wendy Adelson would be the better witness. So what they're saying here is that, yeah, how interesting. See, it wouldn't be admissible elsewhere for someone else to testify to what someone else told them. And here, the Florida statute's like, it is admissible, but it's still, Wendy would be the better option. Well, let's have both. Can we have both? I want both. Additionally, testimony from both Ms. Yousef and Wendy, oh, now they're saying it would be cumulative. I disagree because they're going to have completely different perspectives on it. They're saying it'd be cumulative. Okay. Lack of personal knowledge. According to the Florida statute, witnesses must have personal knowledge about that which they testify. Most of Ms. Yousef's deposition testimony is about events to which she has no personal knowledge. Well, I mean, right now, right off the bat, this is where I'm thinking, well, she does have, it's her perception. And what does that remind you guys of, right? Oh, an exception to hearsay, present sense impression, right? In other words, what was her impression at the time when she was around Wendy? Remember, she was friends with Wendy, best friends, up until 2017. And the murder was in 2014. So she was around Wendy, and yeah. So they're saying she had no personal knowledge. Based on her deposition testimony, the limited personal knowledge she had about Dan and Wendy's marriage came from several divorce pleadings that Wendy sent out to her to read, right? Ms. Yousef also had personal knowledge of a Phil Markel's victim impact statement because she watched it. They really have big thoughts about that victim impact statement. Finally, Ms. Yousef had personal knowledge of conversations with Phil Markel's attorney because she was a participant in those conversations. Overall, she has limited knowledge. There's a certificate of good faith conference. Oh, that's interesting. That's a different type of, oh, and there's the certificate of service. Okay. So next up, filed on May 28th. Motion for extension of time for defendant to complete discovery. So we heard them discuss this in the hearing, right? This is where they're asking for more time. This is not surprising. We already know she's charged with all these. She's charged with first-degree murder, conspiracy to commit first-degree murder, and solicitation for first-degree murder. All the murder things. All the murdery things. Statement of facts. The undersigned filed their notice of appearance on October 22nd, 2024, after the court disqualified Ms. Adelson's previous attorneys. That's why I wanted to read that, right? Because Dan Rashbaum fucked it all up. Based on the order disqualifying counsel, the undersigned counsel requested the state provide the defense with all the discovery previously provided to Mrs. Adelson's previous attorneys rather than obtain materials directly from prior counsel. So, in other words, instead of going to the previous defense counsel to get discovery, they went to the state, which makes sense. Between April 7th and April 30th, the state, quote, dumped, end quote, more than 160,000 emails, disclosed they had conducted an entirely new investigation, engaged in controlled calls, wiretaps, sought and obtained wiretaps, search warrants, and phone records. On April 30th, this honorable court granted the defendant's motion and continued the trial based on the new discovery received by the defendant. The court then set the trial to commence on August 19th. Let's see if that date sticks. I hope it moves again. Dude, I really hope that's not the case still, because Kohberger is going to be starting on August 18th. That's the expectation. No, I cannot. Can we move it to October? Okay. Based on May 2nd, the court entered an order setting a deadline here. The defense has worked tirelessly. They're requesting these different deadlines. Okay. Now, from May 29th. So we're almost caught up, or getting to the end of May here. Second amended order granting court proceeding dates and procedures. Okay, so let's see what he says. So discovery deadline, Friday, June 27th. That was today. Their discovery deadline was today, unless this changes again between then and now. Pretrial motions, June 27th, again today. All these deadlines are today, okay? No further extent. Wait, what about the trial? How come he doesn't mention the trial date? Okay, I went back to this one. So in other words, this is not them asking for the trial. He already ordered, and I didn't read his order, by the way. He granted the motion to continue. I didn't read it because it's like one paragraph, and literally it's like, good cause, I'm continuing it. But I should have pulled it up. Why? Because he gives the date. So he set the date for August 19th. So that's why he didn't mention the date on the amended scheduling order, because he already gave them the date. So the date is set for trial for August 19th, unless it changes. Oh my God. Why? Why is it a day after Kohberger? Oh my God. So that's that one. So then what happened after this? So this is May 29th, right? What happened after this, in terms of between May 29th and today, June 27th, is there was a motion to change venue. And there was a hearing on the motion to change venue. So that's what we will catch up on next time. There's not a whole lot of other new filings. It's like the motion to change venue, and there's like a brief hearing on the motion to change venue, and I'll have to see what else. But basically, this is what we're looking at. I feel like it's going to get continued again if it hasn't already, and we just haven't read the document. Yeah, I feel like it's going to. I don't see this happening. This is just me personally. I don't see this happening. Especially not with all the new discovery that they just got. And it's not just like discovery that the state, let me just reiterate, okay? This is not a situation where the state just like was not turning over discovery in a timely fashion. No. The state conducted a whole subsequent brand new investigation, okay? Complete with wiretaps and everything, right? Like, where is it? Like this must have been going on over the fall. But we didn't know it because it was an investigation. So like, yeah, there it is. Oh my God, that was this year. Jesus. Okay, let me read this again. Between April 7th, 2025 and April 30th, 2025, they dumped 160,000 emails, disclosed they had conducted an entirely new investigation, engaged in controlled calls, sought and obtained wiretaps, search warrants, and phone records. So you see how, like, it's not like the state was delayed turning it over. Like, there was new shit going on. They turned it over. But given all this, I don't see how August 18th is going to happen. Now, having said that, part of what was discussed in the hearing is that all of this shit that happened this year doesn't change anything or have anything to do with the pre-existing charges that have been there forever, right? Again, all of the murder things, as in right here, all of the murder things, that's all the same. And like they said in the hearing, at this time, the state is not adding any new charges. So part of what they discussed is like, well, look, if yeah, sure. This whole thing happened, right? There was more investigation, more wiretaps. However, they're not bringing new charges at this time. And none of that affects the previous charges. So essentially what they're saying is this, yeah, there's all this other discovery. However, should that really affect where we were already at? So that's sort of what Judge Everett is weighing out. However, even in doing that, I wouldn't be surprised if it gets continued further. Wouldn't be surprised. And part of it's going to depend on, guys, because again, all their discovery deadlines, the deadlines for everything. Let me go back to this. All of their deadlines were today. So what's going to happen is if I check, let's just say I go back to the docket on Monday, right, or Tuesday, and there's not a shit ton of filings, then they couldn't meet their deadlines, right? Like, in other words, this is like all the shit should be coming in, okay? All pretrial motions. Like, dude, is this going to be a shit ton of, unless they come in before Monday. It's possible, because sometimes what happens is things will get added to the docket, like in terms of they'll get scanned in court and put on, but we don't see them. So it's entirely possible that like tomorrow or Sunday, there could be a document dump of all this stuff, right? Or it could be Monday, just depends. But what my point is this, pretty soon here, we should see a huge document dump in this case, unless they couldn't make their deadlines. And then all the dates have to get pushed out again, if that makes sense. But the deadline was today. Well, he already denied delaying Kohberger twice. I mean, you know that. I know you know that. And Amelia says she talked to Doug. Oh, good. Tell him we say hi, please. He ran air defense during the bomb. Said the guys were like too quiet. Interesting. I wish I could understand or interpret what that means, but I literally have no idea, because I don't have enough. I have literally no knowledge on what goes on during military things. What if there's another leak and then Hitler does it again? That Hitler is wild, man. Completely. I mean, you guys, y'all were there. Well, those of you who were there, completely did a 180. I mean, it started with him in that hearing, right when the leaks thing first surfaced. It was like, this is a big deal. He even said there could be really serious consequences. He basically was saying, like, reading between the lines, he was like saying, defense, like, now's your time to make a motion to continue, right? Like, he was literally handing it to them. Like, this is a big deal. And he made it was clear as day that the leaks were from law enforcement, from his mouth. And even in his, even when he asked them to turn shit over, the wording in that, there was literally no question from Judge Hitler that the leak was from the government side, not the defense side, right? And that they would find whoever was the source of the leak, and that the leak could completely fuck everything up and then have really serious impact on this trial. And it's like, now it's like, oh no, we are not going to find the source of the leak. The leak doesn't matter. It could have come from literally all those footnotes, guys, that we read last night got crazier and crazier as it went on. Those footnotes were like, what? And then he went on to say, like, there's the whole thing about, well, anything that happened in like Washington or Pennsylvania, like, I can't do anything about, and with that, and like cites nothing to back that up. It felt like a ruse. I don't even know what you're referencing. Was there a bomb threat or something? I don't even know what you're referencing that felt like a ruse, because I don't watch the news, so I'm like so out of the loop. So, but anyway, like, he didn't. It's just crazy. Like, this Hitler did a 180 and contradicted everything he had said previously. And the reason is because clearly those leaks, in my opinion, would be the biggest thing that would continue this trial. Those leaks are a big deal. And the other thing we learned, like I said last night, guys, is that there already has been a special prosecutor in place, which means they are investigating it. That's been going on. We didn't know that. There was nothing that came out that said, okay, we're appointing a special prosecutor. Like, it was talked about, but then there was no follow-up. And it came in a footnote. So now we know it's confirmed. And these are all timestamped, by the way. Everything that I'm mentioning that I'm like, oh, holy shit, that's like crazy. It's all timestamped, and the timestamps are done. So if you missed it, go back and look. But they've got a special prosecutor who's already been investigating. But like, why are you bothering, though, Judge Hitler? Why did you bother to do that? If A, you're like, we're not going to find them. B, whatever they find doesn't have any impact on the trial. C, if they find anything that happened in other states, we can't do anything with it anyway. Like basically, it doesn't make any sense. It makes no sense. It makes no sense. Oh my God, it just pisses me off. Where were the bombs? I don't know. I have no idea. Maybe I just need to like look at the news, but like I don't look at the news stuff. Oh, okay. I had no idea there were bombs dropped on nuclear sites in Iran. And well, wouldn't that set off the nuclear bombs? I mean, isn't it like a chain reaction of bombs? I really don't know. Clearly, like, all. My lack of military and bomb knowledge. Hopefully, I make up with that in other areas. I mean, yeah, exactly, Twiz. There's a lot of reasons why the leaks are important. I've talked about it at length, so I don't want to be redundant. The leaks matter. The leaks are the thing that should either get this trial continued or have the death penalty taken off the table. But they need to be investigated and they need to be solved and found out. It is a problem. It is a real problem. Judge Hippler's initial reaction to the leaks was a genuine reaction. You guys saw how mad he was. You guys saw how serious he was taking it. You guys saw how he was like, this could be like, blow everything up when it comes to this trial. That was not even an intended pun with this, whatever is going on in the news. But anyway, that was his reaction. His reaction was legitimate. That was appropriate. As we've said a million times, judges hate nothing more than when their court order is violated. And especially right before trial, you've got leaks coming out and a violation of, I mean, his response was the correct response, but he has completely done a 180 on all of that. It's really crazy. I have the amended revised, if you want me to pull it up. I've got it. There are a lot of iterations of the gag order, but I have the most recent one handy. I'll pull it up. This is the most recent one, the revised amended non-dissemination order. Let's just go through it again real quick here. Oh, shit, James. That's wild. I wonder if my brother's out there. If there's like, I mean, if it was known that there was going to be tornado weather, please be safe. Okay, so this is the revised amended non-dissemination order. This is from June 23rd, 2023. We're just going to go through this again. So, okay. The following is ordered. Prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys, any attorneys representing witnesses, victims, or a victim's family are prohibited from making extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. This order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following. This is exactly why I was saying last night, and I've said it before, but I also said it last night, that if anyone from law enforcement or anybody who's subject to this gag order, right? If they told Steve Gonsalves or anybody, right, that people kept mentioning him. That's why I'm just going to say, if they told him anything, that's problems. I mean, this lays it out so clearly, right? That they would have a substantial likelihood of prejudicing the outcome of the case, and also that a reasonable person would expect to be disseminated. I said it last night. Literally, if you want to get the shit disseminated, tell it to Steve Gonsalves, right? Because he's like, what did I say last night? So the only way you could be more disseminated, is if you gave it directly to Nancy Grace, right? Like you give it to him knowing that's going to happen, and that's reasonably should have known, reasonably did know. So that relates to the following: the identity or nature of evidence expected to be presented at trial or any sentencing phase of proceedings. Any information a lawyer knows or reasonably should know is likely to be admissible evidence at trial. Character, credibility, reputation, or criminal record of a party, victim, or witness. The identity of a witness. The expected testimony of a party, victim, or witness. The performance or results of any examination or test, or the refusal or failure to submit to a test. Any opinion as to the guilt or innocence of the defendant. The possibility of a plea of guilty to the offenses. Okay, in other words, the possibility of a plea deal. The existence of any contents of a confession, any information obtained by witnesses, any information obtained by witnesses, the victims' families, or their attorneys from the state that is confidential and has not been publicly disclosed. Let me break this down. So what matters here? the first thing that matters is who does it apply to, right? Who? What people? It applies to these people. The attorneys, right? Any attorneys that represent witnesses or victims, defense attorneys, and then like all the agents of the state, basically, right? Law enforcement, right? Anybody who's an agent of the state. So does that make sense, right? That's the first thing. The second thing is where is the gag, right? In other words, when would a leak happen? Well, it would happen when one of these parties, right, talks to somebody who they know would spread that news, right? Would spread that, whatever the thing is. And then the third thing is the what. So the who, the why, and the what, right? That's what it is. The who, the why, and the what. The what, the content, in other words, the content of what is prohibited by the said parties that we just covered. The who, the why, and the what. The what, the identity or nature of evidence expected to be presented at trial. We're just going to go through it again now that we're breaking it down. Any information that a lawyer knows or reasonably should know is likely to be admissible. Character, credibility, reputation, or criminal record of a party, victim, or witness. Identity of a witness. Expected testimony of a party, victim, or witness. Performance or results of any examination or test. Any opinion as to the guilt or innocence of the defendant. Possibility of a plea of guilty to the offenses. Again, possibility of a plea deal. The existence of contents of a confession. Any information obtained by witnesses, the victim's families, or their attorneys from the state that is confidential and has not been publicly disclosed. So again, so in other words, right, when it comes to the court record, anything that's public filings is public, right? That's fine. So what then would fall where, when as far as these categories? Well, this is going to be anything that's sealed, right, as far as the court filings, and then anything that's not in everything else that we haven't seen yet that would come in at trial, right? The evidence, all the evidence. So does that make sense? Let me see what you guys are saying in the chat. Super Planner Girl, that's correct. So for anyone who doesn't know, my brother is a professional storm chaser. Shout out to Mant. Love it. So does that make sense, guys? So what's not mentioned here, though, so far is anything about there being any limitations as to the jurisdiction. It's not saying, think about it, right? Any defense attorneys. So like, in other words, okay, this would apply also, for example, to, you know how Brian Kohberger had when he was arrested in Pennsylvania, you know how he had that initial attorney who did just the limited appearance, as in like the extradition. He was there for like one thing. You remember that, guys? That guy is subject to the gag order because he falls under the who category, right? Defense attorney. It doesn't say defense attorneys in Idaho. It says defense attorneys, right? The same is true of the prosecution, which again, we know all the law enforcement. So whether it's Pennsylvania or Washington or anywhere else, if you're part of the prosecution, if you're part of the government, you're subject to the gag order. There's no limitations anywhere on here of there being any limitations to the jurisdiction. And again, like I pointed out last night, Judge Hippler himself, when he tries to say that there are limitations and that anything from Washington or Pennsylvania is they can't use, I pointed this out last night. He says nothing to back it up. He provides no rule. He provides nothing to back it up. He just says it. It's insane. It's insane. So in other words, there's literally nothing that puts any jurisdictional restriction on anything with this gag order. So then when Judge Hippler tries to say that there's some restriction, he can't provide anything to support that because there isn't. There's no rule, there's no code, there's no statute, and there's nothing in the actual specific order itself that puts that limitation. So there you go. So these are the exceptions, right? Attorneys involved in the case and their agents may make extrajudicial statements concerning the following: the claim or the offense, right? Was he charged with? Information contained in the public record, like, for example, what we covered, the court documents that are public record, that an investigation is ongoing, okay? The scheduling of any result or step, in other words, there's a hearing tomorrow. A request for assistance from the public in obtaining evidence or information. A warning of danger concerning the behavior of a person involved, okay, whatever. The identity, residence, occupation, and family status of the accused, fact, time, and place of the arrest, identity of arresting officers and agencies, any statement that a reasonable lawyer would believe is required to protect the client from substantial undue prejudicial effect of recent publicity, not initiated by the lawyer or the lawyer's client. No individual covered by this revised, amended non-dissemination order shall deliberately avoid its prescriptions by actions, directly or indirectly, that result in. This is clear. Look, no individual covered by this revised. I mean, this is the. It's a shame that Judge Hippler or Judge didn't foresee that there could be a problem, like if he had a crystal ball, right? That he should spell it out and actually say, hey, anybody who falls under the who category and is in other states, this applies to you. But why would he think he has to spell it out? This is, barring that, this is just as clear. No individual covered by this revised, amended non-dissemination order. What does this take us back to? That takes us back to the who category. The who category is clear. We went through that. Shall deliberately avoid its prescriptions by actions, directly or indirectly, that result in violating this order. This revised, amended, non-dissemination order shall remain in full force and effect until the conclusion of a trial and any sentencing proceedings that may follow, unless otherwise ordered by this court. And I love his signature. Judge, I love you and I miss you. Why am I silly? What can he do if they don't follow it? I think this is less about punishing people that do the leaks. Well, he can hold them in contempt of court, right? There can be, depends on who it is. If it's an attorney, you can have sanctions, right? There can be punishments that, I mean, I remember when this came out, I researched it. He can do whatever he wants. Okay, look, whoever violated, if he finds out who violated it, regardless of what state they're in, he can give them jail time. The court, as in the judge, has full reign to do whatever they want, what they see fit as a punishment. If you guys remember from the YSL trial, when that judge who got removed from the bench, or at least taken off that trial, I forget his name, and he's the worst, was holding the lead defense attorney in contempt of court. He sentenced him to 30 days in jail. He could have done longer. They can do whatever they want. It's not like when you have like a criminal charge, right? And there's like a sentencing guideline. It's like, if you do this charge, you're looking at 10 days to 20 days. Contempt of court, they can do whatever they want. It can be fines. It can be, it can be whatever, but jail time is a possibility, right? However, that's separate and apart from the effect it could have on the trial, right? So to me, it's less important. The punishment to who made the leak honestly didn't even cross my mind until this question was asked. I wasn't even thinking about that. I'm not worried about the punishment, right? Like he'll come up with a punishment. The point is you have to stop the leak, but then you have to figure out how is it going to impact the trial. Because again, there could be serious implications there with Brady Giglio, especially for me, the Giglio portion of it, right? Impeachment material, showing bias. I mean, think about this, right? If you've had a law enforcement officer that leaked this fucking content and is responsible for this leak, especially if they're supposed to testify, but even if they're not, that bias is think about like Karen Reed, right? You had Michael Proctor, like the bad app, but like it seeped into the rest of it, right? Because they work as one unit, just like how we say, okay, yeah, law enforcement, they're part of the prosecution, right? Because it's like it affects the entire body of the government, right? So it's like the bias of it, I think would be huge. That alone. But also it's like, we don't even know how many people are leaking and what all is leaked that we haven't heard about yet. I mean, I think this is huge. And I think it's, again, the punishment can come later. Judge Hippler could decide next year what he wants to do. Like if he wants to say, if he holds them in contempt, he could say, yep, I'm holding you in contempt of court, but we're gonna follow up with that we're gonna follow up with that after the trial, and then we'll deal with that. We see that in other cases. We saw that with Karen Reed when Judge Bev was getting all mad at the defense attorneys one of the many times, and she said, like, after the trial we'll figure out if there's going to be sanctions. So they can be applied way after the fact, right? In terms of like, okay, you're the leak, I'm holding you in contempt, but as for what I'm going to do with you, that will happen later. For now, shut your mouth. Don't do it again, right? You can't do it again. But your punishment, you're going to have to sit there and sweat and wonder if you're going to jail, or wonder if you're going to have a huge fine, or whatever it is, right? They're going to have that can be dealt with later. They have to stop the leaks. They have to okay, first of all, they figure out who did the leak. They figure what all was leaked. What's the extent of the leak? They have to stop it from happening again. And then they have to figure out how it's going to affect the trial. The last thing on that list to me is how you're going to punish them, right? Does that make sense? Mm-hmm. Mm-hmm. Yeah. Defense says absolutely. 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 Yeah. And you'll notice I didn't mention the jury pool either. Like the fact that like, I don't know why people are like thinking that big concerns here are the impact on the jury pool and then like punishment. That's not the implications here, to me. And like I think the leaks are a huge deal for all the reasons I just laid out. Right? I mean, whatever we saw in that whatever the document, there's other ones that haven't come out yet, guys, right? There's the upcoming documentary, or at least one in the books. Guys, there could be other pieces of evidence that were leaked that we don't know about yet. And the thing is it's not the media's fault. They have it is not their fault. They are not subject to the gag order. Again, going back to the who. If somebody like, say, for example, Steve Gonsalves told the media, right? He's not subject to it, but he got it from somebody in law enforcement. That's the source of the leak, and they are subject to they fall under the gag order. They need to be stopped. They need to be punished, but that's not the most immediate thing that needs to be decided. What needs to be decided is, what are we going to do from here? How is this going to affect the trial? So hopefully that makes sense. But again, I am extremely disappointed in Judge Hippler for how he's handling both of them, both the documents I read last night, the alternate perpetrator and the motion to continue. I mean, I tried to hold my tongue, honestly, because we had a members only live directly after, and I was like, I could literally sit here and rant for like hours. But like, I have a lot of thoughts on him with this, and I'm not happy with it. And yeah, I mean, yeah. How do you punish someone outside of your jurisdiction? I mean, violating court order is very different than other things. So like, it's not, we need to use the proper terminology, right? When I say punish, I used the word punish because that was the word that I think you used in the question initially, Twiz. The thing is, the mechanism, right, is a holding someone in contempt of court. Any court can do. How do you get held in? Well, there's a number of ways that you can be held in contempt of court, but the biggest one is violating a court order. If you are subject to the court order, as we laid out again in the who category, and you violate the court order, you violated the court order. It's the jurisdiction doesn't apply here, right? It's not like, I understand how it's different if we're dealing with charges that are brought forth, right? Or like establishing jurisdiction initially at the start of, when charges are first being brought. For example, like when you've got, maybe there's question about, could it be federal or state? Or, for example, like with civil lawsuits, right? Like you're establishing the initial jurisdiction, right? That's the whole thing. And then again, like the crimes that are being charged, where you serve out your sentence. Jurisdiction matters for like literally everything, right? Like that we usually see. This is different. A court order is like its own animal. And we saw this again with Karen Reed. And the judge has complete discretion over this. It's like the court order is like the judge's own thing that they create, that they get to enforce, and that they're in charge. It's not subject to anything else. And the thing, again, I'm gonna say it for the last time. All you need for proof of that is that when Judge Hippler put that little footnote in about the different states, he cited nothing to back that up. Why? Because it doesn't exist. There's nothing, there's no statute, there's no rule, there's no code, there's no case, there's nothing to back that up. If it existed, he would have provided it. If it existed, he would have brought that up in the hearing when it first came up. If that were true, this would have been discussed already, and it would have already been a thing. Like literally, now that he's trying to walk it back, now we see a footnote about it with nothing to back it up. Like that blows my mind to just make those statements as if they're fact with nothing to support it. It blows my mind that he did that. Blows my mind. Like I'm just still shocked. He just says it as if it's true. What is he, Jeff Devine? You know, like from Twin Flames last night. You know, I mean, it's like gaslighting. You can't just say things and then it's true. That's not how it works. What? Yeah, that's a good question. I don't know. That's Twiz is mentioning the 911 call. I honestly don't. I never played that because I'm still like, yeah, I don't know. I don't know enough about. I forgot about that. I will just say it's entirely possible that there's been an investigation go into that we wouldn't know about. It's also possible that someone got in trouble and we don't know about it. It's also possible that they found the person, they know who did it. But again, getting someone in trouble is not the prescient issue. That's not the priority. The priority is not getting someone in trouble, right? You know, I mean, is it that they don't know who leaked it? Or do they know who leaked it and we just haven't heard that information? That's also entirely possible. I think there's also word, though, that it was allowed. I don't know. But yeah, it was not on the docket. I never saw it from the court. That's why I never covered it or played it. I didn't even listen to the whole thing. Hi, Kane. Welcome. That's exactly right, Amelia. Amelia's saying if they're working on behalf of the prosecution team, it falls under Brady. It doesn't matter. Right. Exactly. And again, I just have to, again, it's a court order. It's its own animal. Like it is whatever it says, right? Other things that apply to things like criminal charges or other infractions or civil statutes or whatever, that's not what this is. A court order is what it says. And it can be whatever the judge wants. And they can enforce it however they want, and then violations can be dealt with however they want. It's their own thing. That's why judges, like I said, that's why they get so pissed if you violate it, and they take it personally. And Judge Hippler did initially, and then he walked all that back. So that's just so fucking frustrating. So yeah, so anyway, on the next Adelsons, which maybe we'll do tomorrow, I'll just have to see, because again, we might be getting a huge document dump. We will finish up with the rest of the June stuff, which again, there's like the motion to change venue. He's not ruled on that yet, by the way, guys. He's not ruled on it yet. So I expect it to be denied, but there is a motion to change venue. Has not ruled on it yet, but all those other pretrial motions and discovery deadlines were today. And it sucks again that they're slated to go to trial one day after Brian Kohberger is supposed to start. So, or Idaho v. Kohberger, right? So. But I do have to go because I have a lesson here in a couple minutes on one of my students on the West Coast. So, yeah, so we'll have to end it here, guys. But yeah, thank you for mentioning the 911 call though, Twiz, because I don't know, I forgot about that whole thing, and I feel like that got like. It came out and then everyone stopped talking about it and then we never heard another word. Like that's, you know what I mean? Like, I'm like, yeah, how come there was no follow-up to that? And the other thing is this, that 911, I thought this was interesting. I'll just mention this real quick. I expected that to be addressed at the next hearing or in the next filings. What I mean is this, after that 911 call came out, I expected to see something from the defense, the state, the judge, or all of them, probably all of them, right? Saying something about it. Right? Like anything about it. They didn't even acknowledge that it had happened. They didn't even acknowledge it existed. Literally, I mean, they just completely, it's as if they just didn't even talk. The words didn't even come up. And like, I kept thinking, okay, this, at one of these, we're going to see a filing about it. And it's like, okay, no filings. At the next hearing, they're definitely going to talk about it here. And they just didn't. And then I forgot about it. But like, what's the deal with that? Because like, why did they not mention it at all? Did they not know what happened? They have to know what happened, right? It's just crazy. I can answer this. This is okay. The Washington now I don't know if this is true. Twiz is saying the Washington Dispatch said that the non-dissemination order didn't legally provide them from releasing. I'm so glad you said that. Here's why. It's not because they're in Washington. Guys. The WHO. 911 dispatch. Do they fall under the WHO category? Nope. They're 911 dispatchers are not part of the government body, and they're not part of the defense body. They're not in the WHO category, guys. That's why it's not the state. It's not because they're in Washington. It's because they're just 911 call dispatchers. It's the same thing as if something had been leaked from, like, who else would be something that's like they could have access to evidence, but they're like literally not a part of the WHO category. I'm trying to think of who else that could be, because there's like few that I could see that applying to, but dispatchers would be one of them, because they're not working for the government. Like, they're not working for the prosecution the way law enforcement does, right? They're not. Yeah. So, you know, like an ambulance, like a EMS, right? Like an ambulance person, say, for example, right? I mean, I don't know why they wouldn't have it. That's why I'm saying it's a rare category. They wouldn't have access to evidence that they had these in their possession, right? But while they're adjacent to things that involve a crime, the way a 911 dispatcher is, right? They're also not part of the prosecution. They're not part of the government, right? Does that make sense? I didn't see Judge Hippler react to that at all, though. And I've watched every single second of everything in this case, for as far as the hearings and everything. I mean, it's not just Sara. It's literally you guys, there's a lot of other documents. This is the most recent one. There's like a bunch of iterations of this, and every law tuber talks about it. It is not, there's no question, right, that of how broad the term is. It's like when you're an agency, right? When you're part of law enforcement, that you're part of the working for the state. But again, just as examples, like firefighters and EMS people, first responders, apart from police, right? They're like adjacent to, but they're not part of that umbrella in the same way that like a 911 dispatcher wouldn't be part of it. Does that make sense, Twiz? Did you hear that? Because that's important. Because I know that we, just set the record straight here. It's not about Washington. Again, when we look at this, we see the WHO category does not include dispatchers, right? They don't fall in the WHO category. And we also don't see anything about any limitations to the place, the jurisdiction. In fact, we see the opposite. It's because they are not in the WHO category. 911 dispatchers they're not a part of that prosecution umbrella, because they are not involved in, they have no involvement in the investigation of a crime, right? They're not involved in that. They just answer the 911 call and direct the first responders. The same way the first responders are not part of, they're adjacent to, but not part of the investigation. They're not part of furthering charging someone with a crime. Does that make sense? I hope that makes sense. But I got to go because I have a lesson. So hopefully that helps. And I love you guys. We'll be back soon. And but for now, squirrel out.